So hello everyone and welcome to the final of the 2021 Osgoode Cup. Continuing a proud tradition, 17 years in a row. This is the first time being run virtually. And so I appreciate everyone taking the time. I think we've had a great tournament so far and things are continuing as is. I did want to run through just a few logistics in terms of what's going to happen here today, which is also probably going to be telling the judges in terms of that. So we're going to have the mooting competition now. We're going to have the final. The judges are then going to leave. Everyone else is going to stay here, or stay here if you want. And then we're going to leave and we're going to deliberate. And then we're going to come back and give the result to those people who are here. Well, I'm also going to post it online, within 20 minutes or so. So it depends on your factor of wanting to know that right away. And then at that same time, I am then going to announce the top advocate awards consisting of the top advocate and the 9 distinguished advocates for the Osgoode Cup as well at that time. We are not going to run through all of the people who, of course, have done very well, because we don't have trophies for them at present to give to them. Those are going to be couriered to one's houses later, once you then send me your address, so on and so forth, or tell me, I guess you could also pick it up. I don't really suggest that these days. Anyway, so without further ado, that's what we're going to do. We're going to be in here, and then the judges are going to leave. Everyone else is going to stay here. And then the idea is that we would then come back. And for the judges, I will send a link and also send an email to you, giving you that information in terms of you're going to go to my Zoom room, which is a different Zoom room, and we'll deliberate there. Okay, so that way I don't have to kick everyone out here. So without further ado, hear ye. I call to order this final round of the 2021 Osgoode Cup. For those who haven't had to listen to me say this before, my name is Andrew Monkhouse. I'm the convener of the Cup, and I've been running this for a number of years, and I'm an employment and labor lawyer in Toronto. I assist mostly workers, but also companies with their human resource and human rights issues. In no particular order, I would ask Justice Karen Sanchez to also introduce herself.
Hello, everybody. My name is Karen Sanchez, and like Andrew, I am a litigator here in Toronto. I've been practicing, I'm going into my 10th year this year, and I was also a participant of this Osgoode Cup 15 years ago. So I'm very excited for all of you to have this experience like I did, and good luck and congratulations for making it this far.
All right, Justice Kyle Rees.
Hi, everybody. My name's Kyle. I'm a lawyer in St. John's, Newfoundland and Labrador. I'm also a graduate of Osgoode Hall, which is, about a decade ago, I think, that I graduated, something close to that in any event. And I've judged this competition almost every year. I've got 6 or 7 under my belt by this point, so I'm looking forward to seeing you guys present.
All right, Justice Stephen Marchand.
Yeah, hi guys. My name is Stephen. I'm a first-year law student at Osgoode Hall Law School. I am also a former undergraduate mooter and the winner of last year's Osgoode Cup. So I'm excited to pass off the trophy to one of 2 teams who both deserved it and who both worked very hard to get here.
All right, Justice Sydney McIver.
Hi there, everyone. My name is Sydney McIver. I am a 3rd-year student at Osgoode and also a member of the executive of the Osgoode Mooting Society. And I'm also part of the Osgoode delegation for an international moot, which is something we're working on currently. So this topic is something that's quite near and dear to my heart.
Right, Justice Omar Haredai.
Hello, everyone. Omar Haredai. I am a civil litigator by training and run a legal clinic in the GTA, and been judging this moot for several years, as well as other moots in other schools and other forums. And so congrats again, I will say, to all of the finalists for making it here, and we're looking forward to today's session.
Right, Justice Daniel Appellant.
Hi everyone, my name is Daniel. I actually work alongside Andrew at his firm. I handle the small claims court matters for employment law. And I am also a former participant of the Osgoode Cup. I've participated here 4 times, and I've done a total of 10 moots in my undergraduate. Received a couple of distinguished awards, and very excited to be here. I think that this has been a fantastic experience. I'm sure that everyone is pretty happy with how the online competition has gone. So congrats again. And for anyone that I've judged, looking forward to speaking with you in the future.
Right, and certainly not least, but Chris Diaz.
Hello everyone, I am Christopher Diaz. I am a recent graduate of Osgoode Hall Law School. I'm currently articling at a litigation firm. I am a past participant of this competition and have been judging it for the last couple of years. So I'm very excited to see both teams do their stuff.
Perfect. Well, that's us as the panel. And without further ado, we will allow the teams to, start the moot, in which they will introduce themselves as appropriate. So the appellant, whenever you're ready.
Thank you. Before I begin, may I inquire who will be serving as Chief Justice today?
While we're all fairly equal here, if you need to, for logistical reasons, I can serve in that role.
Certainly. Good evening, honorable members of the court. My name is Matthew Orm, and I, along with my co-counsel, Elena Mejia, will be acting as counsel for the appellant, Nevsun Resources. Would the court care for a brief summary of the facts?
No, thank you.
No, thank you. It's okay.
Certainly. I'll be addressing the question of whether the active state doctrine forms a part of Canadian common law, and we respectfully ask the Honorable Court of Osgoode Hall to reverse the decision of the Supreme Court of Canada and allow the appeal to be heard, while also striking the claims of the Eritrean workers. With this, I have 2 submissions for the court today. First, the active state doctrine does form a part of Canadian common law and thus should be applied as such in this case. And second, the claim brought before the court is non-justiciable under the active state doctrine, thus meaning that the Eritrean workers' claims should be struck. And my first point, that the active state doctrine does in fact form a part of Canadian common law. This case is inherently about the rule of law. And even though we do recognize the severity of the actions in this case, it is important to outline this is not the appropriate avenue to seek justice and/or damages, and thus the appeal should not be dismissed in this case. As is outlined in the case of Queen and Bow Street Metropolitan Stipendiary Magistrate, as cited from page 29 or paragraph 29 rather of the record, the active state doctrine is a rule of domestic law which holds the national court incompetent to adjudicate upon the lawfulness of the sovereign acts of a foreign state, and this is directly applicable to the case at bar today.
Counsel, where are these folks supposed to get justice? I mean, they surely can't go in front of a court in the country in which they were beaten allegedly and forced to provide slave labor. So if they can't go to Canada, where the company that was making money off of their backs is located, where can they go? What other remedy do these people have?
Certainly, Justice. And as was mentioned, we do recognize the severity of these human rights infringement in this case, but we do assert as counsel for the appellants that this case would be better served at a court such as the International Court of Justice or a United Nations committee, because these committees and these types of courts are more adapted dealing with state-by-state issues. And in this case, we cannot just rule simply on Nevsun Resources, but we also have to look at the Eritrean government. And if we allow Canadian common law courts to go into sovereign states and rule upon the domestic laws of these states, it would be setting dangerous precedent for future years that would not serve the Canadian justice system well in any manner.
Counsel, isn't what we are being asked to do here is to hold a Canadian corporation potentially liable, and we're not being asked to adjudicate on Eritrean state law in this case at all. They're not even a party.
Justice, while we do recognize the commercial nature of Nevsun Resources in this case, it is clear that while they are in Eritrea and following domestic laws, this is still not the appropriate avenue to seek justice and or damages, because the respondents in this case are looking for payment and damages, but an international court will be able to grant them that if they chose to go to that level. And in this case, it is clear that because it is a sovereign state and a Canadian court, say they were to go into Russia or China and rule on a law there, that would have grave influence or grave consequences for the future of the Canadian judicial system as a whole. And thus, we do propose this explanation to the court to show that we cannot allow a court to go into a sovereign state and rule on their domestic laws.
Counsel, you're saying, please. Counsel, you're saying that you recognize the severity of the human rights infringements, but does the gravity of such human rights infringements actually impact your analysis at all, or are you simply acknowledging it and putting it to the side? Because it seems hard to ask this court to rule in any other way than to support the people who experience these atrocities for an extended period of time, no?
No, Justice, we certainly agree with the severity of these human rights infringements, and we do not condone the actions or the alleged actions of Nevsun Resources in this case. But as was mentioned, a Canadian court cannot be allowed to go into a sovereign state and rule on the domestic laws of that state, and instead it should be taken to an international court who does have the legitimacy and the capacity to rule on these types of issues, as they do in.
But what about the access to justice issue here, counsel? I mean, you mentioned the rule of law, and if you consider the fact that it takes a lot of resources and time to bring an action to an international court, and these people are suffering now, is it not reasonable that in this instance, thinking from an access to justice perspective, that they need recourse and justice now?
Justice,
sorry, counsel, I'm going to piggyback off of my sister Justice as well to say, why should we only afford 1 point in terms of access to justice? Well, why can't there be multiple avenues that we can take?
We do understand the access adjustment explanation and argument being made by the Justice and Co-Justice in front of the court today. But while it does remain true, we also must recognize the severity of the jurisprudence that it would set, allowing a Canadian court to go into a separate country and rule on the sovereign laws. It would hurt international relations as a whole and also public diplomacy in future years.
Counsel, can I just ask quickly, because you continue to make the argument that we shouldn't be going and looking at international or other states' laws, but isn't that what the State Immunity Act really prevents? We're not talking about the State Immunity Act here because the state is not a party.
Justice, while we are not looking at the State Immunity Act in its entirety, we are looking at the non-justiciability doctrine and its applicability to this case and the sovereign laws of the state itself. And because this case and the facts before the court are non-justiciable within a Canadian court and under the Act of State Doctrine, this means that the Eritrean workers' claims should be struck, even though we do recognize the severity of the human rights infringements in this case.
To what degree, counsel, are we really infringing upon the sovereignty of another nation? As I understand the facts pled by the plaintiff, this mine is really something controlled by a few generals, a few wealthy elite within this country to enrich themselves. Should we take that into account in some way? Is this really asking us to pronounce upon, some sovereign act by an independent country, or is this really just sort of a cabal that's enriching themselves and a Canadian company that's taking the opportunity to cash in?
Counsel for Appellants does that we do recognize the commercial nature of the relationship between the Eritrean government and Nevsun Resources as a whole. And while the sovereign nation of Eritrea, they would not like a court such as Canada to go in there and rule on this type of domestic law in that certain state, because even though Nevsun Resources is a Canadian corporation, they are still in Eritrea and following the domestic laws there. And thus, even if they are violating international law, this should be heard on an international level, as was mentioned through the United Nations or the International Court of Justice.
So counsel, I'm going to try to understand this a little bit better. The United Nations or the International Court of Justice is only going to hear matters that involve a state, correct?
Certainly.
So Eritrea could be a party before one of those proceedings, but Nevsun as a corporation could not be, right?
Justice, we do urge the court to recognize that they cannot be separated in this case because Nevsun...
I answer my question. Nevsun as a corporate entity would not be able to go before those entities, right?
Nevsun Resources could go to the international law and the international court along with the Eritrea in their entirety because they cannot be separated. They are a part of the conscription program and they are complicit with the conscription program throughout the fact base of the case as a whole. So thus, even if it is in a commercial nature and Eritrea and Nevsun Resources were acting in a commercial nature, it then remains true that we cannot separate this and we must look at it in one entity. And that is why the Act of State Doctrine does apply in this case, along with the non-justiciability doctrine in the case as a whole. And ultimately...
Can you talk, Counsel, just a little bit about why you believe the act of state doctrine is a part of Canadian common law? Because in so many instances, it was not applied where it could have been.
Certainly, Justice. It is recognized by virtue of what is now Section 2 of the Law Equity Act of 1996 that the act of state doctrine does apply in this manner. And we also urge the court to set precedent today and allow the act of state doctrine to be applied to this case, because it would help Canadian international relations and public diplomacy as a whole in future years. And if we chose not to apply the act of state doctrine in this case, as was the example earlier, if we were to go into a country such as Russia, China, or the United States and deal with these types of matters and their sovereign laws, it would be an international scandal and political consequences that would not serve the justice system and the Canadian country as a whole.
Counsel, if you want to discuss consequences to international relations, I'm worried about what this is going to mean on the plane of international relations if other countries see that Canada is not listening to a case where potential human rights abuses have occurred based on a technicality, which is what I understand your argument to be.
Justice, I see my time is about to expire, so I may just briefly conclude and answer your question.
Sure.
To answer your question, on this level, it is true that while NEVSUN resource in this case, the international relations and the stuff of that nature, there are two sides to the issue. It remains true that if we're not recognizing that the international relations issue do not mean anything in this case, or the human rights infringements don't mean anything, but we are simply saying this is not the appropriate avenue to seek justice and or damages in this case. And if we did allow the Canadian courts to rule on this type of issue, it would be setting very, very dangerous precedent for future years and for future judicial decisions. And that is why we do urge the court to side with the appellants and not dismiss the appeal in this case. And barring any further questions, I now yield my time to my co-counsel to discuss the customary international law claims and submissions in this case. Thank you.
Thank you, Counsel. Okay, Counsel, whenever you're ready.
Thank you. Good evening, honorable members of the court. My name is Elena Mejia, and I rise to continue argumentation on behalf of the appellant. The crux of this case lies in determining if Canadian courts have the power to rule on international law issues. In order to preserve the authority of international courts, respect state sovereignty, and ultimately to bring this matter to a close, this case should not be tried within the Canadian judiciary system. As such, the Counsel for Appellant asks that the Honorable Court of Osgoode Hall overturn the decision of the Supreme Court of Canada and find that customary international law prohibitions against forced labor, slavery, cruel, inhuman, or degrading treatment, and crimes against humanity cannot properly ground a claim for damages under Canadian law. To this end, we offer the following 2 points of submission. First, that customary international law does not form a pure part of Canadian law. And second, that Canadian courts lack the legitimacy necessary to rule on international law issues. To my first point, customary international law does not form a pure part of Canadian law. As cited in paragraph 61, the Counsel for Respondent is specifically seeking damages for breaches of customary international law.
Counsel,
However,
can I just ask you, what do you mean by it does not form a pure part? Are you arguing that it does not form part of the common law?
Thank you for that clarification, Justice Sanchez. We are not arguing today that international customary law does not form in part Canadian common law, as Canada follows the doctrine of adoption, which means whenever we do not have a conflicting internal law already set in our common law, we adopt international customary principles.
So the appellant is essentially asserting that they would like to pick and choose when they should and should not follow customary international law and domestic and have Canadian domestic courts, have their say in matters. You want to pick and choose because it benefits a corporation.
Respectfully, no, Justice. Our goal is not to pick and choose in this case, but rather recognize that international customary law and Canadian common law are not equivalent. Canadian law utilizes international common law. However, when we do so with our own precedent and with following the views and values of Canada as a country. We cannot then say that every decision we make that is made on the principles of international customary law is equivalent to what international law is or what would have been practiced at the International Criminal Court or another international body.
So why wouldn't Canada then be interested in this? Well, why is it that a Canadian corporation shouldn't concern themselves with this kind of conduct and be able to set a start to a baseline
Justice, in this case, the Canadian court does have interest in this case. However, the concern is that we would be overstepping in setting this precedent when it's more appropriate to be heard at an international body. As my colleague briefly addressed.
Doesn't Canada have some responsibility to domestically clean house, so to speak? I mean, if you look at the infringements by Nevison here, these are very serious issues. I mean, Canada is party to, against, for example, the Convention Against Torture. And for us to not enforce these international norms, doesn't that set a dangerous precedent on the other end?
Respectfully, no, Justice. We are not concerned in this case that it sets a dangerous precedent, because we have to look at the individual fact pattern of this case. And the way it is set up is that we are unable to look at Eritrea's national service program without looking at Nevsun together as a whole. As you briefly touched on, we're concerned about torture, as well as concerns specifically about forced labor. Those concerns come ultimately from the Eritrea National Service Program's inscription program.
But counsel, it doesn't seem like that standard's high enough, because what if I posit to you that this has nothing to do with human rights and everything to do about money? What happens then? How does the appellant respond to that?
In that case, Justice, if we are to be concerned about money specifically, we'll need to look at the intentions of Nevsun and recognize that the goal here is not to dodge responsibility, but rather have it be seen in another court. To further expand upon financial concerns, we need to be aware that Canada is deeply entrenched in many different mines across the globe. Additionally, Canadians every day use products that are produced in factories around the world. While we do wish to clear house and make sure that our corporations are held accountable, we must determine to which extent and be mindful in the impacts this precedent would make.
Counsel, can I take you back to your original statement that you're accepting that parts of international customary law is part of the Canadian common law? Of course, you must recognize that preemptory norms and just cogens norms, such as the prohibition against torture, do form part of Canadian common law. So how then do we escape holding Canadian corporations accountable for those preemptory norms for which no derogation is possible?
Justice Sanchez, we do agree that these are international norms. However, that does not mean that in this case, Nevsun would be skirting responsibility. The goal in this case is for it to be seen by a correct body so that we can establish the layers that exist in holding responsibility. If we are to see Nevsun in court solely, there's the potential that they could be held responsible for the actions of other parties or for the Eritrea National Service Program. Nevsun,
what domestic remedies does your client, does the respondent have then? Because if you're advocating for this to not be heard before a court in Canada, despite it being a Canadian corporation, I fail to see how telling a bunch of individuals who experience human rights atrocities should take the time to go out to an international court when we should be able to address their issues at home. Can you make me feel better about that?
Absolutely, Justice. As far as a domestic remedy, we encourage the executive body to take action. The separation of powers doctrine is essential to the way the Canadian system works, in that no branch of government can have more power than another. If we're allowed,
is it clear that the executive hasn't already made a determination on this? I mean, again, these are preemptory norms. These are norms that every nation across the world essentially agrees cannot be permitted. And so in this instance, perhaps the executive just assumed that it was known to the courts that this is something that they should be enforcing. Should they really be taking additional action on this, or had they already spoken?
Justice, if we are to believe that they have already spoken on this matter and disagree with the decision of the court, the executive body would have the power to instate new orders that go against what was said by the judiciary. However, in this case, the executive body would be able to get proper reparations for these individuals, while this is also heard at an international level.
Counsel, how much responsibility are we putting on the executive if there's any case that could potentially implicate international relations or have anything to do with a foreign state, now the court is putting it on the executive to deal with those problems? I have a problem with that precedent going forward.
I understand your hesitancy, Justice. However, when we look at international diplomatic relations, those fall squarely into the role of the executive. So we would not be expanding their powers by that much more if we were to allow them to step in and discuss on these issues.
Well, counsel, just sorry to interrupt you there. I'm concerned about something because it seems like there's a lot of afforded protection for corporations. You have state immunity, you have the active state doctrine. It seems like there's a great lack of protections when it comes to employees who have suffered from this egregious conduct. What do we do about that? There's already protection for corporations. How much further can it extend?
Justice, we are not aiming to let corporations be all-powerful or to extend it so that they're able to hide behind multiple doctrines. Rather, the aim in this case is to identify where states have sovereignty and what their motive is in being involved.
So, counsel, then, is it your submission that there was no state involvement here, that customary international law could apply, in fact, to Nevson?
In this case, Justice Hared, we identify that there was involvement of a state government.
No, my question is more simply, I'm trying to figure out what the objection is. So if there was no state involvement, could customary international law in your submission extend to a corporation?
Yes, Justice. In that hypothetical, we believe that it could extend to corporations. However, there is no past jurisprudence that says that that should be the case.
So that differentiates your point from the dissent that at the Supreme Court?
Yes, correct. Ultimately, Justices, this is additionally a political issue. We have to recognize that corporations, as well as individuals, are entwined within this case. It's incredibly easy to look at this case solely from the human rights angle, but we must recognize that even when aiming to remedy human rights issues, we must take a breath. We must hesitate to fully grasp the scope of what these precedents could cause. And in this case, we need not worry only for corporations and their abilities to work outside of Canada, but we have to worry about our ability to be within diplomatic relations in a proper way. And we must also think about individuals who are in countries where we have conflict. This case, in deciding in favor of going forward and holding Eritrea alongside Nevson responsible, could potentially prove to be dangerous for any Canadian nationals who live within that state. Ultimately, Canadian courts are greatly overstepping their authority if they're to take on this case. And in doing so,
Counsel?
Thank you. Barring any further questions, I yield my time. Thank you.
Thank you. And the first counsel for the respondents, when they're ready.
Good afternoon, honorable justices of this court. My name is Rebecca Tiley with my colleague Avery McKinley. We are here on behalf of the respondents, Mr. Guys Yabeo Araya, Mr. Kasete Tekeli Fisayon, and Mr. Mirtab Yaman Tekeli. It is a respondent's position that the Supreme Court of Canada was correct in allowing the Eritrean workers to bring forth claims and damages arising from alleged breaches of international law. We respectfully request the Supreme Court of Osgoode Hall to dismiss this appeal and uphold the lower court's decision. At issue before this court today is that the active state doctrine and the doctrine of justiciability should not be applied to protect a private corporation which has violated peremptory norms simply because the actions of a foreign state are involved in the periphery of this case. To address this issue, the respondent will make 3 submissions. I will address the first 2, and my colleague will submit the last. The first submission is that the active state doctrine does not apply in the case at bar. The second submission is that this case is justiciable as it does not rule on a foreign state, but is rather concerned with holding Nevson accountable. And the final submission is that the appellants have not met the high evidentiary threshold to strike these claims, and that the claims brought forth can be heard under customary international law. I'm now beginning the first submission. While we can see that the active state doctrine does exist within Canadian law, as our friends have submitted, it has never been applied in Canada. It would not apply in the case at bar. If it did apply in the case at bar, this case would fall under one of the exceptions as outlined in paragraph 37 in the case at bar, which cites the 2012 England and Wales Court of Appeal case of UCO's Capital Sarl and OJSC Rosneft Oil Company, that the doctrine does not apply to foreign acts of state, which are in breach of clearly established rules of international law, are contrary to principles of public policy, or where there is a grave infringement of human rights.
Counsel,
what do you say to your friend?
You have a concern. Do you have a concern that this law is being applied to these corporations retroactively, and the freezing effect that would then cause for Canadian corporations? Because Nevson would say that they are adhering to the laws in which the country in which they're operating. And now they're being held liable for something that they never thought that they would be.
If this case were to be heard, we would not be discouraging Canadian companies from doing business abroad, but rather discouraging Canadian companies from violating peremptory norms abroad and holding them liable for their own actions. Secondly, this is not a choice of laws case, whether or not Eritrea's laws apply, but rather the issue here before us today is one of justiciability. To that end, our second submission is that this case is justiciable, as it does not rule upon a foreign state, but is concerned with holding Nevsun accountable.
So, counsel, if I understand your friend's submissions correctly, they've said that the liability of Nevsun and the government of Eritrea is quite intertwined. So let's say that this court decides to agree with that submission. Would we not be ruling on the liability of the Eritrean government with that intertwining of liability? And the reason I ask is I'd specifically like you to deal with the State Immunity Act to describe how you would not see that actually being barred then.
The State Immunity Act is not engaged in this case, as Eritrea has not been listed as a party. And secondly, a court may consider the legality of the acts of a foreign state under international law if the issue arises merely incidentally, such as in the 1993 Supreme Court of Canada case of Hunt and TNN, and the 1990 U.S. Supreme Court case of W.S. Kirkpatrick and Environmental Tectonics Corporation. The respondents here today do not bring claims against Eritrea, just Nevsun, and this court would not be required to make a finding that is legally binding upon a foreign state.
Counsel, I understand that the focus of the respondents' claims is only talking about Nevsun, but can you please walk me through, on the facts of this case, how a Canadian court could possibly find Nevsun liable without also finding the Eritrean government liable?
Just as we acknowledge that, logically speaking, in order for the allegations to succeed, that as Nevsun was a party to Eritrea's actions, this court would also have to acknowledge Eritrea's actions. However, this court is free to pronounce an opinion and make that determination as long as it is preliminary to the final decision of a question, as per the 2011 High Court of Australia case of Moti and the Queen. And in that case, it states that simply calling into question the decision of a foreign state does not in and of itself prevent the courts from considering an issue.
Counsel, what this court has to say about the Eritrean government's labor programs is not merely going to be academic. There are going to be real world consequences if this court says any Canadian companies that do business with this allegedly human rights abusing regime are going to be suable, are going to be actionable and financially potentially responsible in Canadian courts for dealing with that government. I mean, that has real world consequences for that government and what companies that government can do business with. So isn't this better left to sort of the diplomatic political realm? Do we endanger making this court a political body by making such rulings?
If I've understood your question, that this would be better left to the executive branch and that perhaps this would undermine the executive branch. This court does have the capacity to consider questions of international law, and it does regularly rule and consider evidence of human rights records of foreign states in the context of extradition and deportation. Now, in those cases, these courts consider evidence of human rights practices of foreign states without far-reaching implications. And furthermore, as per paragraph 54 in the case at bar, a court considering evidence is not the same as an indictment upon that state. As per the Supreme Court of Canada case of 2017, case of India and Videsha. We'd also like to draw a clear distinction between a court referring to the acts of state for the purposes of proving their existence as a finding of fact, and a court's ultimate finding that is legally binding. The fact that this court may have to make a finding of fact regarding Eritrea's involvement would still not constitute central, because this court would not be adjudicating upon the legal effectiveness of the Eritrean National Service Program, and that final decision would be legally binding upon Nevsun.
Isn't this a slippery slope, though, counsel? I mean, if Nevsun were found to be liable in this case, doesn't that then open the floodgates for every single Canadian corporation that is even involved in a whiff of human rights abuses to then be liable. Isn't that quite a large step in the jurisprudence?
This would not open the courts to a universal civil jurisdiction. And furthermore, it is our position that Canadian companies should be held liable and responsible for their actions abroad. And they should be discouraged from violating peremptory norms when doing decisions abroad. To not adjudicate this case here today would effectively immunize corporations that have foreign states simply involved in the periphery. Contrary to what our friends submitted, that it would be dangerous precedent, it is our position that it would be a dangerous precedent to allow Canadian corporations to escape liability, to fail to hold our own Canadian corporations accountable for violating human rights because of—
Counsel, what about, if we enact this sort of civil long-arm statute, what about other countries deciding to hold us responsible under their laws? Isn't that the problem here as well, that suddenly, Eritrea or Russia or some other country can choose to say, well, Canada did this, and so we're going to now go after Canada for our laws? Doesn't that open us up in that way?
If I've understood you correctly, we would not be seeking to apply Canadian laws to an Eritrean company. We're seeking to apply Canadian laws to a Canadian corporation. And while there is some involvement of that foreign state, it is not central, but merely incidental. Silencing these Eritrean workers who have had their rights violated by a Canadian—
Counsel, when you say incidental, are you talking about 40%?
No, Justice, I'm referring to the involvement of the foreign state as being merely incidental.
Oh, okay, not the ownership capacity.
Counsel, sorry, if that discussion is finished, I wonder if you're perhaps mischaracterizing the argument of your friends. They're not saying that corporations can run rampant and do whatever they want. They're not saying that the respondents are going to be silenced. They're simply saying that international means of justice are the right avenue for this issue to be heard.
I see that my time has almost elapsed. If I may have a moment to address your concern and briefly conclude. The international criminal courts, which our friends posit is the correct avenue for this, those courts are for actions between state actors, not private entities, such as in this case. And in the case at bar, the purpose of the active state doctrine and the doctrine of justiciability was and still is to protect the constitutional separation of powers. The misapplication of these principles to allow a private corporation, which has violated peremptory norms, to escape liability in a case where the foreign state's involvement is both incidental and preliminary would subvert the original purpose of those doctrines.
Could you kindly make— yeah, thank you.
Barring any further questions, this concludes the first two submissions on behalf of the respondents.
Thank you, counsel. Whenever you're ready.
Good afternoon, Honorable Justices. My name is Avery McKinley, and I will be concluding the final submissions on behalf of the respondents in the case at bar. Our final submission is that the claims brought forth can be heard under customary international law, as national courts have the ability to develop the Canadian common law incrementally. To begin, pursuant to the United Nations International Law Commission's report, to adopt customary international law, there must be widespread state practice and opinio juris.
So counsel, I'm going to stop you there just because your friends have provided a novel argument that it is not necessarily that the law cannot be extended in that way, but that it shouldn't be extended in this way on these particular sets of facts. And so is it possible for you to refine your submissions to address that particular submission that was made?
Yes, Justice. The appellants did not consider that there is opinio juris on the record, and this opinio juris is reflected in the ratification of several international covenants and treaties, such as the International Covenant on Civil and Political Rights, the ICCPR. And the Vienna Convention on the Law of Treaties ultimately binds Canada to the ICCPR because In the Vienna Convention at Article 2, Section 1b, it states that whereby a state establishes itself on an international plane, its consent is bound to the treaty.
So, counsel, just to get a clear understanding, is your position, respectfully, that it's up to a Canadian domestic court to create such an incrementally large precedent for widespread use? It can't be up to anyone else, because your friends, they did make a very good point that it has to be very specific on the set of facts over here. So is your point that it can only be up to our Canadian domestic courts?
Our position is that Canadian domestic courts are the best avenue to adjudicate on these matters. And
but that would undermine the executive branch.
Not necessarily, Justice. The executive branch is not suited to this because these are civil claims, and also because the judiciary is capable of assessment.
I mean, counsel, if we want to develop our law, take another leap forward, the executive has had plenty of opportunity to do that. If I recall, the first hearing in this matter, I'm not sure when the claim was filed, but the first hearing was in 2016. It's been 5 years, and there's been nothing but silence from the federal government, from the BC provincial government, so not that they'd have jurisdiction anyway, on this particular matter. You know, should we be concerned that that silence indicates that there's not an endorsement of the court's attempt to incrementally increase its jurisdiction over these kinds of matters?
No, Justice. The silence of the executive does not constitute an answer. And additionally, it is well within the court's jurisdiction, as you mentioned. And while the Vienna Convention may be old and it may not necessarily always reflect modern international law, Canadian courts need to move with international law to help move, and Canada should be a part of that. And in conformity with the ICCPR, Canada is obligated to ensure an effective remedy to victims of violations of those rights.
So I appreciate your submission there. Sorry, go ahead. Go ahead.
Thank you. So just jumping on the last point you made, and it's a question I've had in my mind. If I were to accept that customary international law is part of Canadian common law, how do we then get to a remedy? What is your proposal for actually implementing a remedy as against this company? Would it be a tort, or how would it be implemented?
And counsel, I do want to address something after you answer that, okay?
Damages would ultimately be up to the trial judge after the claims are raised, Justice. We are merely here just to allow for these claims to be raised.
Counsel, so along with this, and you know, my sister Justice brings up a really good point about remedy, because we have to ensure, and I appreciate and understand that the law is not frozen in time, that it is a living and a growing tree, but there needs to be consistency inside of it, right? This whole argument about defining the term incremental, whether large or small, it's an important topic that we need to that we need to discuss together. So if we want to remain consistent, why do we want to leave leave the executive branch out of this? Why do we want to undermine their power?
We wouldn't necessarily be leaving the executive branch out of this, as if the claims were raised, the executive branch does have the capacity to essentially make comments or speak to the judicial branch about these. However, this also includes protecting the rights of private persons and entities. And this includes the respondents here today. And the covenant rights can directly be applied by the judiciary. There is no reason for the executive to step in. And if they really did have a problem with us adjudicating, perhaps they would create legislation which prohibited us to do so. And pursuant to the 2007 Supreme Court of Canada case, the Crown and Hape, this doctrine of adoption operates in Canada such that prohibitive rules of customary international law should be incorporated into domestic law in the absence of conflicting legislation. Our friends raised concerns about this having...
Counsel, is it your position then that corporations being liable for abuses of Yus Cogan's norms, is it your position then that it is customary international law that these companies are held liable?
Well, we can see that this is a novel case and there isn't widespread state practice. It is not yet a norm. However, it is a norm to hold parties accountable for the violations of Yus Cogan norms. And I would also like to make a key distinction between the case of Friedman and the case at bar, because Friedman is the case which essentially cites the incremental argument. And in that case, the court dismissed the appeal because the rule in question, the sealed contract rule, did not cause hardship or inconvenience. And the difference between that and this case is that the incremental change in law proposed today should be raised because of the severity of these claims and because international law is a part of our common law. Slavery is not the sum of its parts. This is essentially why customary international law, why these Yus Cogan principles should be grounded in Canadian law.
Counsel, are you aware whether or not Canada would be the first to be offering a civil remedy based on customary international law being part of common law?
Canada would be. However, in the case of Kybal and Royal Dutch Petroleum, the United States has an alien tort statute, which essentially allows for foreign nationals to bring claims against corporations in the United States. And while it has not yet extended to customary international law, as Canada has the doctrine of adoption, it is possible for us to begin this widespread state practice today.
But counsel, doesn't the existence of that particular statute in the United States speak to exactly the need for executive involvement? If I'm thinking the correct statute that you're referring to, I mean, I think it was one the United States passed in order to allow victims of the 9/11 attacks to recover financial compensation. If it's the same statute, I think it is. So, I mean, doesn't that just cry out for executive involvement before we would allow a court to take such steps? I mean, the Supreme Court of the United States didn't take those steps on their own, did they?
The distinction between United States law and Canadian law is that Canadian law can use the doctrine of adoption as long as there's no legislation which prohibits us. And in the United States, the separation of powers may be a little bit stronger. And if these claims continue to be brought forth and not adjudicated on, we are silencing the voices of people who have been abused by our own Canadian corporations. And this is where access to justice is truly frustrated.
Counsel, if you want to talk about silencing individuals who may have been punished by corporations, then I have a problem with this kind of remedy coming in a private matter, a civil matter, where the things that are discussed and the remedies that are reached can be private. And the reason I say that is because I think that your client's claim is better placed in a criminal matter where the concerns that you're raising, like cruel and inhuman treatment, forced labor, those are protected under criminal statutes.
Justice, may I address your question and then conclude?
Yes, please.
This would be an entirely different case if it was a criminal matter. These are damages which are being brought forth against a corporation. And ultimately, it wouldn't make sense to ground this in criminal claims since we have already made it this far in adjudication. The appellants have failed to meet the high evidentiary threshold to strike the claims. And to conclude, I would like to cite Chief Justice Beverly McLaughlin as she then was. She stated in Imperial Tobacco, and I quote, "The law is not static and unchanging. Therefore, justices, the law must move. And we submit that it must move in the right direction where, based on the submissions made by our friends today, may succeed today, but also tomorrow and forevermore. For this reason, along with the submissions made by my co-counsel and I, we respectfully request that the Honorable Supreme Court of Osgoode Hall dismiss this appeal, uphold the lower court's decision to ensure that Mr. Gezeya Beo Araya, Mr. Kasete Tekeli Fasayon, and Mr. Mirtab Yaman Tekeli have their voices simply heard. Barring any further questions, this concludes the submissions on behalf of the respondents. Thank you, Justices.
Thank you very much.
Well, thank you very much. That concludes the argument portion of the Osgoode Cup. As mentioned, what we're going to do now is that the judges are going to, we're going to take this case under advisement, but given the, to understand that there have been briefs filed about the urgency of this matter, we're going to do that and then return back to you very shortly. So judges, I should have sent a link that you should be able to access to be able to switch over to that other Zoom link on my other computer that's right over there. And so if you could start doing that now, and then we are going to revert back to this room. I do have a brief video to show folks in this room, although that's only going to be about 10 minutes. We'll see how long it takes for the deliberation, but we'll be back when we can as well. So judges, if you could move to that link now. I've also emailed you, so why don't you get heading over there now? Thanks. All right, so thank you. Certainly an interesting system, having this go as clearly as we kind of can try to do so virtually versus the normal physical approach. Certainly something that we're doing. So I think the judges are trickling back in now after recusing ourselves in a different Zoom room rather than an actual physical room down the hallway. And we are ready to give our decision. Before that, I say that just because people won't listen after that. I do want to say, first of all, a lot of discussion back and forth in terms of the judges, many whom had extremely strong views. I have to say what happened in the end was that some judges felt very strongly that one team should win, and some judges felt very strongly that the other team should win. And in effect, it became a secondary debate about the strengths and weaknesses of those individual teams. That being said, given the fact that we had people waiting, we eventually, I see the smallest justice is now with Justice Haradai there. And that being said, we eventually had to form a vote after having everyone say their piece, but otherwise we would be here till midnight and nobody would want that. But I did want to say that everyone was very impressed with how responsive people were to questions. This is a difficult moot because your time is limited. I mean, people do not meaningfully say you have 10 minutes to present a case. Interventions, at the Supreme Court at 10 minutes, you don't expect questions, and here you're getting 10, 20 questions within 10 minutes. We thought the pacing was good. I mean, this is a difficult time with it being virtual, but we thought that people did well with regard to that. And there was a significant argument about the strengths and weaknesses, but mostly strengths of the different teams. With all that being said, we do have a result. It was a 5-3 split decision, which made me consider strongly that probably in the future I should have odd numbered panels. But luckily that didn't come up in this case. But after taking into account all of the factors, including the fact that we did think that we had taken into account a burden issue, because we do think that it is harder for one side than the other, we did end up, notwithstanding that, siding with the respondent from McMaster, Rebecca, and Avery as being the team that was in the end successful and the winner of the Osgoode Cup 2021. So the respondent was the successful team. Congratulations. And so I do want to note, and it was noted, we did think that the appellants had a harder case, but we still sided, as said, the team sided narrowly with the respondent.